Welcome to our comprehensive guide on competition law. In this video, we'll explore the fundamental principles, market structures, and key legal frameworks that shape competition policy. Whether you're a student, professional, or simply curious about how markets operate, understanding competition law is essential. We'll start by examining the role of prices in the market, move through different market structures, and then dive into the legal mechanisms that ensure fair competition. By the end, you'll have a clear grasp of how competition law impacts businesses, consumers, and the economy as a whole. Prices play a crucial role in aligning the quantity supplied with the quantity demanded. When a good becomes scarce, its price rises, signaling both firms and consumers to adjust their behavior. For firms, higher prices may encourage increased production, while consumers may seek alternatives or reduce consumption. This dynamic ensures resources are allocated efficiently. Markets are often defined by how prices are determined, and this process is central to understanding competition. The interplay between supply, demand, and price forms the backbone of market economics and sets the stage for competition law. Markets can be categorized into four main structures: perfect competition, monopolistic competition, oligopoly, and monopoly. Each structure differs in the number of firms, product differentiation, and barriers to entry. Perfect competition features many sellers with homogeneous products, while monopolistic competition involves differentiated products and easy entry. Oligopolies are dominated by a few large firms, often with standardized or differentiated products and difficult entry. Monopolies have a single seller, unique products, and high barriers to entry. Understanding these structures is vital for analyzing how competition law applies in different contexts. Competitive model describes the rivalry among firms in the marketplace. This rivalry drives innovation, efficiency, and consumer choice. The state of competition is the result of this ongoing process, influenced by market conditions such as the number of firms, product differentiation, and information availability. Competition law seeks to preserve this rivalry by preventing practices that hinder fair competition. By understanding the competitive model, we can better appreciate the importance of legal frameworks that support healthy markets. Several factors determine the form of market competition in an industry. These include the number and size distribution of buyers and sellers, the degree of product differentiation, barriers to entry, and the amount of information available. For example, in agriculture, millions of small farms produce outputs that are imperceptible compared to the total market. Product differentiation also plays a role. Homogeneous products like number 2 yellow corn are indistinguishable, making price the key decision factor. Barriers to entry such as economies of scale or government policy can limit new competitors. Perfect knowledge and information further shape competition, ensuring firms operate efficiently. Perfect competition is characterized by many sellers offering identical products, easy entry and exit, and perfect information. Firms in this market are price takers, meaning they accept the market price without influence. Profit maximization is the singular goal, and non-price competition is minimal. This structure is rare in reality but serves as a benchmark for analyzing other market forms. Competition law often uses the concept of perfect competition to assess whether markets are functioning efficiently and to identify practices that may distort competition. Monopolistic competition features many sellers offering differentiated products. Entry and exit are relatively easy, and information is readily available. Firms compete not only on price but also through product features, branding, and marketing. Non-price competition is common as businesses strive to distinguish themselves. This structure is prevalent in industries like retail, restaurants, and consumer goods. Competition law examines monopolistic competition to ensure that differentiation does not lead to unfair practices or barriers to entry. Oligopolies are markets dominated by a few large firms, which may offer standardized or differentiated products. Entry is difficult, and information is not equally available to all firms. Industries like sugar, steel, autos, and breakfast cereals often exhibit oligopolistic characteristics. The concentration ratio measures the percentage of the market controlled by the largest firms, with CR4 indicating the share held by the top 4. Oligopolies can lead to coordinated behavior, making them a focus of competition law due to the risk of collusion and reduced consumer choice. Pure monopoly exists when only one seller controls the market, offering a totally differentiated product with no free entry or exit. Information is imperfect, and the monopolist is a price searcher, setting prices to maximize profits. Monopolies can arise from barriers to entry, patents, or government policy. Competition law scrutinizes monopolies to prevent abuse of market power, ensuring that consumers are not harmed by high prices or limited choices. Firms grow through internal expansion or external mergers. Horizontal mergers combine firms in the same industry, while vertical mergers involve firms at different production or marketing stages. Conglomerate mergers unite firms from unrelated industries. Competition law regulates mergers to prevent the creation of market structures that facilitate anti-competitive behavior. By overseeing mergers, authorities aim to maintain a competitive landscape and protect consumer interests. Competition policy encompasses all government actions that influence competition, including tariffs, subsidies, regulation of monopolies, and infrastructure development. Competition law, in a narrower sense, focuses on designing, implementing, and enforcing rules to minimize restrictive business practices. The main objective is to eliminate practices like collusive tendering, resale price maintenance, and abuse of dominant position. Effective competition law defines unlawful conduct, investigates violations, and provides mechanisms for redress and sanctions. Competition law distinguishes between behavior and structure. Rivalrous behavior impacts other firms, but intervention occurs only when it negatively affects competition. Some behaviors like collusive bidding are always unlawful and prohibited per se. Others, such as supplier agreements, are evaluated under the rule of reason, weighing public benefits against adverse effects. Market structure can facilitate or impede competition, and mergers are regulated to prevent anti-competitive structures. This dual focus ensures both conduct and market conditions are addressed. Horizontal conduct involves agreements between firms at the same functional level, such as manufacturers or retailers. Examples include price agreements, collusive tendering, and market sharing, which are often perceived prohibited. Vertical conduct occurs between firms at different levels, like manufacturers and wholesalers. Most vertical restraints have minimal effect and are evaluated under the rule of reason. Competition law categorizes these behaviors to analyze their impact on market competition and consumer welfare. Abuse of dominance refers to a firm using its market power to engage in anti-competitive behavior. Definitions and thresholds vary across jurisdictions, but the core concept remains similar. Authorities investigate dominance based on market share, conduct, and impact on competition. Legitimate business practices are distinguished from abuse, ensuring that only harmful actions are penalized. Exemptions exist for sovereign acts, labor markets, regulated industries, and certain agreements, reflecting the complexity of competition law. Economists play a vital role in competition law by measuring and analyzing market activities, forecasting effects of firm behavior, and explaining findings to stakeholders. Their expertise helps authorities evaluate the impact of mergers, conduct investigations, and assess regulatory interventions. By providing data-driven insights, economists ensure that competition law decisions are grounded in sound economic reasoning, promoting efficient and fair markets. Natural monopolies occur when a single firm can produce output at a lower cost than multiple firms. Regulation includes rate of return, price caps, access rules, vertical separation, and price monitoring. Competition law relies on these mechanisms to prevent abuse and ensure fair access. By regulating natural monopolies, authorities balance efficiency with consumer protection, maintaining competitive markets where possible. Structure conduct performance. SCP theory analyzes market behavior by examining structure, conduct, and performance. Structure includes the number and size of firms, entry barriers, and product differentiation. Conduct covers pricing, marketing, and innovation. Performance assesses consumer welfare, efficiency, and innovation. SCP theory suggests that competitive structures lead to better outcomes, but critics argue it oversimplifies market dynamics. Despite limitations, SCP remains a useful framework for assessing mergers, antitrust violations, and regulatory interventions. Rational choice theory posits that firms and individuals act in their self-interest, making decisions to maximize benefits or minimize costs. In competition law, this theory helps authorities analyze potential anti-competitive conduct, such as predatory pricing or collusion. While influential, rational choice theory is criticized for assuming perfect information and rational behavior, which may not always hold true in real markets. Social norms and ethical considerations can also influence decisions, highlighting the need for nuanced analysis. Potential competition theory recognizes the importance of future competitors in restraining market behavior. A firm may be considered a potential competitor if it has the ability and intent to enter the market. Anti-competitive conduct that deters potential competitors can violate antitrust laws, even if no actual competitors exist. Mergers between firms that could become competitors are scrutinized under this theory, ensuring that the threat of entry maintains competitive market. Entrenchment theory focuses on dominant firms using market power to prevent competitors from entering or expanding. Practices like predatory pricing, exclusive dealing, tying, or bundling can entrench dominance, limiting competition and innovation. Authorities may prohibit such conduct, promote market entry, or break up dominant firms to prevent entrenchment. This theory highlights the long-term harm of anti-competitive behavior, even if short-term consumer impact is minimal. Reciprocity theory addresses situations where firms exchange favors or benefits, such as price fixing or market allocation, instead of competing on merit. This collusive behavior harms consumers by reducing competition, leading to higher prices or lower quality. Competition authorities investigate and act against such practices to promote fair competition. Reciprocity theory underscores the risks of collusion and the importance of prioritizing consumer interest. Bigness is badness theory suggests that large companies inherently pose risks to competition. Their size can give them advantages over smaller firms, making market entry difficult and reducing competition. Authorities may investigate and act against exclusionary conduct or abuse of dominance to prevent harm. Critics argue that size alone does not indicate anti-competitive behavior, and focus should be on conduct rather than scale. This debate shapes how competition law addresses large firms. Federal Trade Commission Act of 1914 established the FTC as an independent agency to protect consumers from anti-competitive practices. Key sections include prohibitions on unfair methods of competition, powers to investigate, block anti-competitive mergers, prevent interlocking directorates, and seek injunctions. The FTC's broad mandate ensures that businesses operate fairly, promoting competition and safeguarding consumer interest. Copperweld Corp v. Independence Tube Corp. The Supreme Court addressed whether a parent company and its wholly owned subsidiary can be considered separate entities for antitrust purposes. The court ruled they are a single entity and cannot conspire with each other to restrain trade. This decision clarified the intra-enterprise conspiracy doctrine, impacting how antitrust claims are brought against corporate groups. The focus shifted to conduct between independent companies. Monsanto Co. v. Sprayrite Service Corp. Involved exclusive dealing agreements that prevented customers from buying herbicides from other manufacturers. The Supreme Court ruled Monsanto's policy was anti-competitive, violating the Sherman Antitrust Act. This case established that exclusive dealing can be illegal if it forecloses competition and clarified that small businesses can challenge anti-competitive policies. The decision reinforced the importance of protecting market access and consumer choice. U.S. antitrust laws originated in response to trusts controlling entire industries, leading to high prices and limited choices. The Sherman Act 1890 and Clayton Act 1914 laid the foundation, prohibiting unreasonable restraints of trade and anti-competitive mergers. The Federal Trade Commission Act created the FTC to enforce these laws. Over time, courts developed the rule of reason, balancing competitive effects. The Chicago School emphasized consumer welfare, while recent reforms focus on market imperfections and dominant firm conduct. Rule of reason allows courts to weigh all aspects of an arrangement to determine if it unreasonably restrains competition. Per se rules deem certain practices, like price fixing and market division, always unlawful. The quick look test is used for clear but not per se restraints. These frameworks provide certainty and efficiency in legal analysis, ensuring that only harmful practices are penalized while allowing pro-competitive arrangement. Section 7 of the Clayton Act governs mergers, acquisitions, and joint ventures. It prohibits transactions that may substantially lessen competition or tend to create a monopoly. The scope includes stock and asset acquisitions, with a lowered standard of proof for anti-competitive effects. Enforcement is carried out by the FTC and Antitrust Division, aided by pre-merger notification requirements. Penalties for noncompliance include civil fines and equitable relief. European competition law began with the ECSC Treaty, aiming to ensure equal access to coal and steel and diminish concentrated power. The EEC Treaty established a common market and prohibited anti-competitive agreements and abuse of dominant position. The Treaty for the Functioning of the European Union (TFEU) further refined these principles, prohibiting restrictive agreements, abuse, and state aid. The EC merger regulation prevents mergers that significantly reduce competition, ensuring a fair and open market. Article 101 TFEU prohibits agreements that restrict competition, with exemptions for those promoting efficiency and consumer benefit. Market power is analyzed based on the ability to maintain prices above competitive levels or reduce output and innovation. Authorities assess the nature and content of agreements, market characteristics, and pro-competitive effects. Leading cases illustrate the balance between prohibiting anti-competitive practices and allowing beneficial cooperation. The goal is to maintain an open, distortion-free system of competition within the EU.